We're scheduled this week.
And
I'm gonna call it real quick.
Love it.
Are we live?
Should I get right to it?
Yep.
All right, we'll just get right to it. So today, I was thinking that we would kind of do an overview of the legal process. So when I use terms like motion, complaint, initiating documents, the discovery, summary judgment, motion for dismissal, these things, what am I talking about and kind of where do they fall in the process? So what I want to create is kind of a timeline of an anatomy of a case and then point out when these different things are happening. And that will kind of give you a logistical overview of, hey, what's actually happening in this case, or what is the lawyer talking about? Where are we at? Give me the plain and simple, is this thing gonna resolve? Is it not gonna resolve? What's kind of the next step? The first thing that we do at MLA, Minnesota Legal Assistance, is we prepare all the documents, right? So what we're doing is we're preparing the evidence for a potential case. We're helping consumers to document errors on credit reports and to try to remediate those in a non-judicial way. So we're not intending on going to court right out of the gate, but we're preparing if we have to. So those documents are the credit reports themselves, the credit disputes, the documentation in terms of identity, and sometimes documents from original creditors or collectors, correspondence of many different types that the consumer has had before coming to MLA. What we're doing is we're getting all those documents together, putting them in a file, and preparing them as kind of that evidentiary background, a kind of history of what's happened. And eventually, it transitions from the MLA document prep team / credit dispute team. So we've got the MLA We've got the MLA credit dispute team over here, and then we have the litigation team over here. So what happens at the two different levels? We just described the document prep, getting everything ready to go, and if we are not able to resolve the credit dispute issue, then we're going to avail ourselves of the federal law. At that point, we're going to say, hey, look, we think a violation has occurred under the Fair Credit Reporting Act, and because a violation has occurred, we're entitled to bring a case and force you to comply with the law. Because a lot of the time, that's the heart of the issue, is that if this system worked properly, we would not need the litigation team. The litigation team comes into play time and time and time again because there is a refusal by the consumer reporting agencies to comply with the law, okay? And it's an unfortunate thing that our nonprofit can't just function over here and help people to dispute the item and remove the item. It's unfortunate. They refuse to comply with the law, and because they refuse to comply with the law, we force them using our litigation team and we initiate a lawsuit. So that's kind of the big picture of what's going on here. So what is the litigation team actually doing? Okay. The first thing that we're doing is reviewing the file. The second thing that we're doing is, if we review this file, we determine that there is a violation and that we think that we can do something about it in the court system, we'll then inform the client, right? And we'll transition them from a credit dispute client to a litigation client, okay? And this is where you would have somebody sign the client representation agreement. We're up in the air whether or not we kind of do this on a contingency basis. We're tweaking this and figuring out how. But what you might see if you engaged a different lawyer, you might see a flat fee basis. This is where you would pay a sum of money, certain, and no matter where the case kind of resolved or when it resolved, that flat fee that you paid would be all you paid as a consumer. That would be very uncommon in a FCRA case because the gambit of possibilities exists here. You might pay a flat fee up through a certain stage in the case, and we'll circle back to that. So that's one form of client agreement. Another one that you might see is the traditional contingency. So the contingency is you will pay a percentage of the money that you receive on the back end. Or if you receive nothing, you don't pay anything. So this provides some insurance against spending money on a case that goes nowhere. And it also provides an opportunity for people who don't have upfront cash to be able to litigate their case. Another form that we might do is an hourly fee agreement. And that would be very uncommon for an FCRA case, especially for a nonprofit to be doing it in that manner. This is where you pay a lawyer an hourly fee, say $200-300 an hour, and in exchange they'll work the case and take it through, or however far you need to take it. So we've got reviewing the file, right? We've got the client agreement, and then once you've executed the agreement and they've researched the case, they've reviewed the file, you're going to do something called preparing the initial documents in the case, okay? And the initial document, the document that starts a case, is comprised of a complaint, all right, and a summons. The summons says you are compelled to go to court. That's the thing that you're served with. Well, you're served with the summons and complaint, rather, but the summons is the thing that's ordering you by the court to show up and to answer the complaint. The complaint is a document that says, hey, this is what happened. This is my claim under the law. This is how, this is the relief that I'm seeking. This is what I believe you did wrong, and additional facts which kind of give background and describe what happened. The complaint is, what we can go into this in greater detail, the complaint, but suffice it to say that the complaint requires procedural steps and procedural hurdles more and more in federal court. Federal court pleading standards is what this is referred to. One of the first things that you will have your defendant do is try to dismiss this action based on an insufficient complaint. Your complaint doesn't state X, Y, or Z, and therefore, because you missed this tiny technical error, or you didn't plead something correctly, therefore your entire case should be dismissed, and they'll argue it should be dismissed with prejudice, which means you can't bring it again. So there are two forms. There's prejudice and without prejudice. Without prejudice, you can bring the case again. We'll circle back to that. The next thing that happens is you'll go through, from a high level here, we'll go through the discovery phase, right? And what happens there is you have written questions that will go back and forth. You'll have depositions. You'll have, of those written questions, I can say that there are three main documents that you'll see. You'll see something called interrogatories, requests for admission, or requests for production of documents. So let's write those down, actually. Deposition kind of sits alone. That's going to be a statement under oath, typically recorded by a court reporter, sometimes via video means. More and more we're seeing depositions happen via Zoom in 2021. The written documents, again, we've got the interrogatories, which are questions. Tell me why you think that this case doesn't have merit. The requests for production are, give me all the documents that you have in your possession. If you received a dispute from me, give me a copy of that dispute. What are we doing there? We're proving that that dispute was sent and it was received by the CRA. Request for admission. Admit that you did nothing to investigate this claim. That would be an example of an RFA. The next stage that you move to, quickly running out of room here, is the motion stage of the case. And again, you had some motions in response to the complaint, but generally you'll see something called summary judgment, otherwise referred to just as SJ. You'll see motions in limine. Hey, if this case goes to trial, you should be able to argue this or not argue that. A variety of other pre-trial motions, and then eventually you'll get to the trial. Okay, and then there's certainly the appeals process, and we can go all through that, but we want to focus today just in here, because this is where most of our cases resolve. I don't have statistics off the top of my head, but suffice it to say a very small number of cases actually reach the trial stage. Most of the time, once you've gone through discovery, you have an idea of whether or not this case has merit. And generally, when you're dealing with large, sophisticated parties that have lawyers and rational parties associated with them, it's not just about feelings. Once we make that determination of whether or not liability exists through the process, a lot of the time, intelligent lawyers kind of can figure out where this case is going. And generally speaking, there'll be some form of resolution at this stage, or certainly after the motion stage. And sometimes you just need to figure out points of law, and we'll go into why each of those things are. But for now, let's go back to the complaint stage. So when we get the documents in, we've investigated, we've again initiated the complaint or a summons and complaint. At that stage, we've got an active case. Once that case is served, in Minnesota, the rule is once the case is served, you've got an active case going. It doesn't actually need to be filed with the court. Yeah, it's called pocket service. It's a unique rule to Minnesota and a few other states, but the point is the case is initiated upon service, not upon filing. Okay, so a case is actually going, and sometimes you'll see cases kind of litigated up through the discovery phase with never being filed. So the lawyers are just kind of agreeing and saying, okay, well, and then sometimes you'll see other cases filed. Generally, when we're dealing with FCRA cases, we're generally going to see, even though we serve them and we don't file them, right? We serve them. Generally speaking, they are going to do something called remove the complaint. So they actually do file the complaint and they bring it up to a federal court from a state court. We typically at MLA will initiate these cases in state court, and the defendant in the case can bring that from the state court to the federal court, which we can go into in a later talk about the differences between state courts and federal courts. But for simplicity at this point, we'll say that generally speaking, we're in a federal setting for FCRA cases. And that's mainly because the big three almost universally will remove the cases to federal court. So within the federal court standards, the case is actually commenced upon filing, but that's irrelevant for our purposes because, again, we are initiating down at the state court level, and we're the people initiating. They're not. So the case is initiated when the summons and complaint are served upon the defendant. Logistically, how does this work? Typically, you'll print off a piece of paper and bring that to the service of process agent who's located over in St. Paul for the big three. So it's a fairly simple process. The complaint, a well-drafted complaint, is drafted up and sent to either a process server or one of our guys who takes it in a pile and drives it over to St. Paul and hands them their stack of complaints for the day. The process server then transmits that information to the defendant. That's unique to companies. Okay. Once the summons and complaint are drafted, if there's not any major errors or problems with the case from a pleadings perspective, you'll move into the discovery phase, or in some cases they'll bring something directly to a motion. But let's say there is a problem. So somebody doesn't have standing. Standing, it means that you are the person who is entitled to bring the case, that you've suffered real harm. This is an ongoing issue after a federal case called Robbins v. Spokio, or Spokio v. Robbins was the eventual case name as it was appealed to the Supreme Court. But suffice it to say, they, in that case, said that it isn't just okay to make allegations. And this is unique to, or I should say, particularly relevant in consumer cases. You actually have to have real harm, is what Spokio said. In order to be in federal court and keep your case going, you have to allege that something actually bad happened to you. You can't just say, nothing bad happened to me, but they violated the law, and because they violated the law, I'm entitled to my statutory damages. If we recall, the damages available under the FCRA. When we say damages, what are we talking about? We're just talking about money available and different ways to get it. But damages under the FCRA are actual damages. Statutory. Actual statutory attorney's fees. Punitive. So you can't initiate a case if nothing has actually harmed you. You simply just, they violated the law, and they violated the law with regard to my credit report, and I just simply want my statutory damages of, let's say, $1,000. That's all I'm going for. Well, it turns out that the case in Spokio stated that if you don't allege some type of actual harm in the complaint, your case is dismissed because the federal courts don't have standing under Article 3 of the Constitution, which establishes the judiciary, to hear those complaints and to hear those cases in controversy. So that is a very, very important concept when we're pleading. And you see how the average Joe now has more and more difficulty in gaining relief in the federal court system. Who would have guessed that, somebody can violate the law, and the law can be very clear. It can say, you violate the law, you're subject to $1,000 of statutory damages. That seems pretty clear to any normal human being reading the law and being a victim in one way or another. But if they bring that complaint in federal court and they don't allege the actual harm, their case gets thrown out. I mean, how is a normal person off the street ever supposed to litigate a case pro se in federal court now? It's difficult. There's more and more and more barriers to prevent people from simply gaining quick and equitable relief for clear violations of the law. So, I hate to say it, but you initiate that complaint, that consumer complaint in federal court, have a lawyer. Have a lawyer. Luckily, there is a deep bench of zealous consumer advocates that understand and appreciate the position of consumers and are willing to work on that contingency fee basis. Because without them, consumers don't have a lot of recourse as it stands. Okay, obviously there's going to be the person who's incredibly talented and skilled and is able to read all the surrounding law, and no matter what your talents and skills, you better have a ridiculous amount of free time to go ahead and try to do that. But by the way, if you do all that, you are not able to get attorney's fees. So if you litigate it yourself, the Supreme Court has said, no, you don't get to get paid. You don't get to pay yourself for those attorney's fees. No, those are reserved for hiring an attorney. So if you didn't do that, so now you're doing all this work for free, unbelievable time consumption. Doesn't make any sense. So that is the pitch for using a qualified advocate. As much as I dislike it, I think that you should be able to simply plead your case and give a simple explanation of how they violated the law, but apparently that's not good enough. So, once that complaint is done and you're through the motion to dismiss and for failure to state a claim or insufficient service of process, that's another thing you see, right? Joe Schmo brings his complaint, and he looks up Equifax's corporate address, and it's building over in Bloomington. And he drives the papers over there and says, hey, is there an officer here to receive service? And the secretary comes out and says, I can take those, and takes them. Well, guess what? Not an officer or director, not at the proper service of process address. Lots of arguments why your case has never been initiated. Insufficient service of process, 2-year statute of limitation. Guess what? Your case is gone and you can't ever bring it again. Make sure you serve things right. Lots of barriers to somebody bringing a complaint. Once you get to the discovery phase, we're typically targeting these to our well-pleaded complaint. We're seeking information and trying to obtain information relevant to proving the facts in our complaint. And at the end of discovery, we typically will have enough information to either bring a motion for summary judgment or to say, this case is going to trial. It will not be dismissed at the summary judgment level. If we think that that's the case, they will sometimes bring the motion for summary judgment. Sometimes we will bring a motion for summary judgment. What does summary judgment mean, and what are the standards? So the two main ways of getting rid of the case are certainly the Rule 12, and honestly, 12b-6 is the most common, really, failure to state a claim. So you'll see that in response to the complaint. Then you won't typically see these things come up again until you're through the whole discovery process. And then once you're through the discovery process, you'll say, Judge, there are not facts here for a jury to decide. This case can be decided upon the law, and there's no dispute of fact. There's no dispute of fact because, particularly in FCRA cases, we have all the paperwork. There's honestly, in the FCRA cases, there's very little dispute of fact most of the time. The questions typically arise, as to whether or not it's the procedures that exist were reasonable, whether or not the investigation that took place was reasonable. That might be a factual question, but honestly, it's not really a factual question as to what actually happened during that process. You can say, well, we transcribed something wrong, and there's not a debate of whether or not that was done because it's all in the documents. So juries are typically there to resolve factual disputes. Judges are there to help with the legal dispute side. And it doesn't always, it does not always require a finder of fact to make a decision in these cases. As is often the case, the judge will be able to decide it based on law. And that is particularly the case for FCRA claims. Because again, documents. These are highly document intensive cases. So that's when we go all the way back to preparing our file. This is where these things come up later. This stuff ends up all the way over here and eventually at issue here before a court. And I think that's why this is so important over here, to get that stuff right on the front end. Because eventually we're sitting in federal court and we're arguing whether or not a case should be dismissed after we've gone through all of this. So those disputes, and I'm not trying to freak people out because they just need to be clear and they need to address the thing. But we're generally not trying to play any games with these things. We're saying what's wrong on the credit report, and like I said, if they take it off, great, that's awesome. But unfortunately, it most often requires the assistance of the litigation team to force these CRAs to actually just follow the law. And the reason for that is, quite frankly, I think they've made a business decision. I think they've said, when you look at what people have to go through to actually get any money out of this thing, I think we're better off just litigating, a few thousand of these cases each year for how much money we're making elsewhere. And guess what? Joe Schmo's never going to make it through the first wicket, so that is going to be easy to deal with. So why not? I think it's a business decision as to complying with the cost of compliance with this law and the cost of actually assuring that people have a fair and accurate credit report. It's just too expensive. So they're just like, we'll just pay the judgments as they come up. I honestly think that's the thing. And then, they say, on top of that, we have all these protections, right? We have increasingly hard pleading standards. We have situations where, the consumer lawyers are potentially overworked, you know, there's a smaller bench of these people, so therefore a smaller bar of these people, and therefore, you know, on the whole, we can kind of reasonably calculate what we're going to pay each year, and we compare that to the cost of actual compliance, and it makes sense to violate the law. So that's kind of the brief overview of what's going on here. You know, again, the major motions that we'll see is the motion to dismiss under 12b-6 or one of the related. This is motion, whoops. And then over here, this is called motion for summary judgment. So, you know, and if it makes it through the motion, you know, I should close on this. In the event that you make it through the motion for summary judgment, at that point, either the plaintiff makes it through if the defendant brought a motion for summary judgment, or the defendant makes it through if the plaintiff brought a motion for summary judgment. At that point, you go to trial. The judge has said, you know, there's factual issues at play here that need to be determined by a jury. There you go. That's how you make it to the trial, or need to be heard at trial if a jury isn't present, and the judge still would have to hear all the evidence in order to make that factual distinction. Because I will say, the use of a jury has to be demanded by one of the parties. So you can still have a trial where a judge is a decider of fact as well as law. And in those situations, the judge will kind of sit in that dual role situation. But judges are good at doing that. So, you know, it is important, if you want a jury, to demand that jury on the face of the complaint. Another procedural hurdle. So it really is important to understanding this process and understanding kind of where we're at in the process in order to get kind of that big picture of, hey, what is my case worth, where is it at, and what is the expected time frame. You know, finally, I think it's important to look at the time frame of things. Reviewing the file, drafting the complaint, right? This can happen in 30 days without much trouble here. Okay, and then so this discovery stage. So then typically what will happen is the court will set a time frame moving forward, and these time frames are a little ridiculous. But this is roughly 1 year. And those if we're lucky, it's 1 year, and sometimes it's 16 months. So, you know, can you get aggressive and you know, get things, get through the discovery phase, ping the other attorneys and say, hey, look, you know, we've got some hard evidence. This thing's going to go to trial. We're billing fees here, and should we get this case settled? Yeah, you can. So I mean, it's a real question. I mean, can you get this done in 60-day turnaround? Yeah, if you've got an aggressive attorney, that's possible. But the attorney doesn't drive the bus on it. You have to have the other side willing to cooperate. There's a lot of factors there. I see these things happen, you know, in roughly 60 to 90 days. That is actually pretty common. Those higher value claims, though, they just do not settle those big cases. You're not getting $1 million in 30 to 90 days. You are those cases that are, you know, $1 million cases, that is happening after summary judgment. It's happening on the eve of trial. That's the way that works. They have to justify it to their higher ups that they've kind of gone through this stuff and done the due diligence necessary to settle a case of that value. You'll never see that early, unless it's something truly egregious, but I've never seen that situation. Yeah. All right. How about you guys?
That's great.